Hello! Welcome to All A+ Essays, the best among the best. My name is Julie and I will be your instructor as we read through Bulldogs Rugby League Club. The article source is embedded in the video description below. Feel free to read along. Please note that you can get a custom, plagiarism-free essay for as little as $10 a page at All A+ Essays. The link is in the description. The case Bulldogs Rugby League Club and Anna v. Williams and Ors 1 gave the situation to the court to consider the doctrine of restraint of trade under common law and the Restraints of Trade Act 1976, NSW. 2. In this analysis, it will identify the relevant issues and ratios based on the relevant facts in this case, and critically analyze the court's decision. Facts and issues. The first defendant, Sonny Bill Williams, had signed up a 5-year contract with the plaintiff, Bulldogs Rugby League Club Limited, in 2007. Williams agreed to the clauses included subclause 3.1 (t), which is the player restrained participating in any other football match of any code without the prior written consent of the Bulldogs. In July 2008, Williams and the second defendant, Toulon Rugby Club, entered into a contract that Williams would represent this French club to participate the competition for August 9 season. And Williams played a trial game on August 8 for Toulon in the same year. The plaintiff sought an injunction prohibiting the first defendant representing Toulon to play. 3. To determine whether this injunction could get the consent of a court, the major issue for the court to consider is whether the restraint was valid and necessary to protect the interest of those parties whom in favor of these restrictions. 4. Ratio decidendi. 1. A basic principle is mentioned by the Supreme Court: the sanctity of contract. The party should be enforced to undertake the obligations agreed under the contract. 5. As an employment contract between these plaintiffs and defendants, the obligation of defendants should be enforced. 2. The general rule from Lumley v. Wagner is used by the court: if the contract is for the provision of special services, the promise by contractor that he does not to work for a competitor should be enforceable. 6. 3. The restraint of trade would be reasonable if it protects the employer's legitimate interests and is not injurious to the public. 7. This is the central principle applied in this case. Analysis and evaluation of the decisions. To determine whether this restriction is valid, first thing to be considered is whether the employer has the interest need to be protected. 8. The restraint must go no further than is necessary to protect that interest of the party. 9. In this case, the court indicated some reasons the plaintiff sought for an injunction: to prevent injury to the player, the importance of promotion of Mr. Williams for the recruitment strategy of plaintiff, and the value of star traction created by Mr. Williams for the Bulldogs, etc. 10. These terms affected by Mr. Williams are related to the actual interest of the plaintiff. Another reason to support the reasonableness of this restriction considered by the court is the sanctity of contract. 11. From the principle in Doherty v. Ullman, the person whom undertakes a considered obligation under the contract should be enforced to carry out the obligation. 12. In this case, Mr. Williams should be enforced to undertake this considered obligation by the contract. A general rule about special services is also used by the court, as the rule states that if the contract involves providing special services, the promise not to work for a competitor will be enforced. 13. Under the situation, Mr. Williams agreed to present the Bulldogs to participate the rugby competition. This would be the agreement of providing special services. Therefore, the promise for Mr. Williams not to work for a competitor should be enforced. Furthermore, he negotiated with the Bulldogs under the freely and fair circumstance. 14. So far as this, the bargaining is fair between both parties. From the different aspects of argument above, the plaintiffs have the interest needed to be protected. Secondly, the court should consider whether this restraint is not injurious to the public. The general rule indicates that every person has the right to trade freely. Any trading behavior interference with individual liberty is contrary to public interest. 15. However, there are some exceptional circumstances exist. In NSW, restraint of trade is valid to the extent to which it is not against public, is stated by the S4, 1, of the Restraints of Trade Act 1976, NSW. 16. In the case, The balance of convenience was taken by the court to determine the Bulldogs would keep their promise to continue paying Mr. Williams payment under the contract, which is the obligation the plaintiff need to carry out. 17. Moreover, the defendant had the freedom to earn a living. 18. Even if the injunction is granted, he also has the opportunity to work for the plaintiff as long as the salary is being paid. 19. After analyzing these issues, it is figured out that the defendant had the freedom to order his affairs for his own and public interest. 20. Therefore, the restraint would not be injurious to public interest. Commercial significance. In this case, the court illustrated what extent for the restraint of trade clause is reasonable. As the matters of employment contract are complex, the businesses should thoughtfully think about whether the extent to provide a restriction under Restraint of Trade Act is effective. 21. However, this doctrine may be used by the employers to restrict their employees' freedom at some points. Thus, the employees should be carefully to consider the impact of the restraints when they enter the contract. In addition, the doctrine of restraint of trade is significantly used in protecting the confidential information for the businesses. Like the case Woolworths Limited v. Olson and Anner, for example, the plaintiff successfully appealed an injunction to protect their interest in case of disclosure of their confidentiality. 22. Conclusion. The decision in Bulldogs Rugby League Club Limited and Anner v. Williams and Orrs affirms that the restraint of trade would be reasonable and enforceable if it protects the legitimate interest of employers and it not injurious to the interest of public. 23. Furthermore, if there is a contract for provision of services, the promise not to work a competitor would be enforced. 24. References. 1. Bulldogs Rugby League Club Limited and Anner v. Williams and Orrs 2008, NSWSC 822. 2. Restraints of Trade Act, 1976, NSW. 3. Bulldogs Rugby League Club Limited and Anner v. Williams and Orrs 2008, NSWSC 822. 4. Restraints of Trade Act, 1976, NSW, S4, 1, 5, Doherty v. Ullman, 1878, 3 Appcast 709 at 720, 6, Lumley v. Wagner, 1852, 1 to GMNG 604, 7, William, K. 2009, September November Commercial Law Quarterly 3, 8, Catanzarity J., 2008, Terminating a Fixed-Term Contract, LAW Society Journal, p. 44, 9, Johnson, J. 2009, Restraint of Trade Law in Sport, e-Publications at Bond, 10, Bulldogs Rugby League Club Limited and Anner v. Williams and Orrs 2008, NSWSC 822, 11, Fender v. St. John Mild May 1938, AC1 at 36, 12, Doherty v. Ullman, 1878, 3 Appcast 709 at 720, 13, Lumley v. Wagner, 1852, 1 Da. GMNG 604, 1852, 42 ER 687, 14, Kuro v. Beyond Productions Proprietary Limited, 1993, 30 NSW LR 337, 15, Nordenfelt v. Maxim Nordenfelt Guns and Ammunition Company Limited 1894, AC 535, 16, Restraints of Trade Act 1976, NSW, S4, 1, 17, Bulldogs Rugby League Club Limited and Anner v. Williams and Orrs 2008, NSWSC 822, 18, Woolworths Limited v. Olson 2004, NSWCA 372, 19, Bulldogs Rugby League Club Limited and Anner v. Williams and Orrs 2008, NSWSC 822, 20, Vancouver Malt and Sake Brewing Company v. Vancouver Breweries Limited 1934, AC 181, 21, Woodward, J. 2010, What do I need to include in an effective restraint of trade clause in an employment contract? 22, Woolworths Limited v. Mark Conrad Olson 2004, NSWCA 372, 23, Restraints of Trade Act 1976, NSW, S4, 1, 24, Lumley v. Wagner, 1852, 1 to GMNG 604. Thank you for taking your time to listen to me. I hope you enjoyed learning about Bulldogs Rugby League Club as much as I did. Kindly remember that you can get a custom, plagiarism-free essay at All A+ Essays for as little as $10. The link is in the description. See you next time.